Hello there, it's another Saturday morning. You're welcome to Prime Insight. This is where you ought to be every Saturday morning because here we call it the battlegrounds for ideas. And of course, we do that based on some of the topical issues that we've heard of throughout the week. That's what we do here on Prime Insight. But the unique thing about this is that, of course, we allow our in-studio audience and you watching us at home to be a part of the show. So feel free to do that once we go live on all of our social media handles at Joy Prime on Facebook and X. You can, of course, join us with your comments. We'll get to read them here on the show. And then those in studio as well will get to have their take on some of the topical issues that we're looking at for the week. My name is Blessed Soga, and of course, it's a pleasure to be welcoming all of you to the show. I'll be telling you about my guest for the morning shortly, but we can't do that without giving you a sense of what we will be looking at this morning. Is the NPP divided, or is the United Party more united now? That's the controversial question this morning, as one stalwart of the party, as we know him, Alan Kojo Chirmating, is now taking a step further to form a new political party. He used to be a leading figure in the NPP, but now says it's time to go back to the roots of the party, picking up a historical name, the United Party, UP, which stands for a traditional and ideal that, of course, the NPP believes in. And many are questioning as to whether or not that will have an impact on the party, which says it is focused on winning the next election. We'll take a look at this new UP, which is emerging from Movement for Change, and as we know it, Movement for Change came from the New Patriotic Party in the lead up to the 2024 elections. Now, officially, they are a political party. The NPP earlier extended amnesty to all members, all party members, those who had left before the elections and during the course of the elections, to return and to form a more united front going into the 2028 elections. But it appears that leadership of the UP is not interested in that. They say they're interested in giving birth to a new political vehicle that will much more, in their view, champion the ideals of the UP. Will this be Ghana's new third force that, of course, many have been on the lookout for? We'll look at all of the implications and more for you here on the show. But in just the last 24 hours or so, the former Chief Justice, safe to say now, Torkonoo, has been back again, challenging some processes. In fact, some say it's a rehash of her concerns about the Justice Poman Committee that led to her removal. But now she's scaling up the concerns because she's asking the courts to injunct or perhaps halt the inauguration or perhaps the vetting of any other Chief Justice, because she believes that the decisions of the Poman Committee were irrational, according to her lawyers. So we'll get into her reliefs and what she's asking the courts to do this morning, and then we'll get into all of those issues for you. But just a recap, first of all, so we get the concerns of the former Chief Justice, why she's concerned that the process has not been fair so far. Listen to this, and then we'll get to have the thoughts of my guests on this.
Even though there is no constitutional instrument passed to regulate the proceedings of an Article 146 committee, Ghana has a constitutional instrument regulating the work of all commissions or committees of inquiry. This is the Commissions of Inquiry Practice and Procedure Rules 2010, CI 65. And in Article 1467 of our Constitution, if a committee is set up for the removal of a Chief Justice, the committee is supposed to, quote-unquote, inquire into the petition, the answer, and the prima facie case. Therefore, we are dealing with a committee of inquiry. In spite of this, on 15th May, the committee decided, without listening to my lawyer, that it will conduct the hearing not as an inquiry, but as litigation. So they rejected the use of CI 65, which was created for the regulation of inquiries, and said they will use the High Court Civil Procedure Rules, CI 47. Then they decided that each petitioner can conduct as his case as he sees fit. So they don't need to present the petition to them. Then they decided that the petitioners can call public officials to confirm what they themselves have not testified to. So, ladies and gentlemen, because the proceedings are being conducted as if it is a normal litigation between the petitioners and myself, their lawyers now choose and pick which parts of the evidence that public officials present to put on the table. This is also in violation of known rules regarding proceedings of a committee of inquiry, because a committee of inquiry must have its own lawyer, and when it starts the proceedings, the petitioner becomes no more than a witness for the committee to prove the allegations that led to the setting up of the committee of inquiry. So the public officials who have been summoned supposedly on subpoenas without the issue of subpoenas just come and swear oaths and present documents to the committee as exhibits. The witnesses themselves do not have the petition. They do not know the allegations in the petition, and so they cannot answer questions on the petition. And when they finish submitting their documents, my lawyers are called on to cross-examine them. Since 23rd May 2025, this strange process has been followed up, and witness after witness has been called, like Nebuchadnezzar's situation, in which he demanded that the magicians in his court should tell him his dream and also interpret it. My lawyers are left to guess which allegations in the petitions that I received on 27th March are supposed to be the subject matter of the testimonies that the witnesses.
Okay, excerpts there of the concerns of the former Chief Justice at the time. Now the President has taken his decision, so we know what the official government position is, that Gertrude Torkonoo would no longer be the Chief Justice. She's up again fighting, and this time round she's adding two more concerns. One has got to do with, benefits as Chief Justice, or if you may want to call it former Chief Justice. Then there's the concern about the swearing in of a new Chief Justice. She wants that process to be put on ice for a bit while the court looks at all of the concerns she's been raising, calling the process unreasonable even in the first place. Well, my guest for today, I call it a table of lawyers now, isn't it? Kweku Ansah-Asare is the former director for the Ghana School of Law. He's joining us via Zoom. We'll have former director for legal for the NDC, Abraham Maliba, also join us online. Then in studio, we have lawyer Koesuman, who is the counsel to former President Nana Addo Dankwa Akufo-Addo. We have Dr. Yaw Educhum. He's not the one actually running for the NPP presidency. This is the Afafranto one.
Yes, very right.
So Dr. Yaw Educhum is also joining us. He speaks for now the United Party. It used to be Movement for Change. He speaks for the UP now on economic matters, but obviously has some concerns and takes on the Chief Justice issue. Lawyer Wayoe Ghanamannti is the 2024 running mate of the Convention People's Party. He's already in Parliament asking Parliament to impeach the President. I wonder why he started that process already. Some say too early in the day, but you say we can't wait. We can't wait enough, isn't it, Council?
Galamsey is very serious. So we cannot wait when we are all extinguished before we begin to do what is right.
Right. So we'll hear a bit more from Council later on the show. But you can be, as I always indicated, a part of the show. Just send us your comments, send us your concerns, and we'll get to read them out. And then, of course, my studio audience will also have their take on all of these matters. Yaw Ansah-Asare, I want to start off with you if you're with us. Good morning to you, and thank you for getting up as early as this to join us here on the show. But let's start off with the tape we've heard from the former Chief Justice. Now she's, back again in the court. You say that she's behaving as though, the position she used to hold is her personal property. I mean, that's how you're describing all of this. But don't you see any basis in all of the points lawyers have stated in this new attempt in court?
Thank you very much, and good morning.
And if you could just sit up for us a bit so we can see your visuals then. Yes.
Yeah.
Right. Okay. That's yeah.
You okay now?
Yeah. I think that's better. Yeah.
Okay. Yeah. So sure. Yes. So the matter is now a beating Ambil. Been back and forth. She's been running amok, to various fora, ostensibly to seek justice, as if justice, cannot be said in Ghana. Now, this is a matter, that arose from the establishment of a special committee appointed, by the president in consultation with members of the Council of State, and she's trying to draw an analogy between the institution or the judiciary and the chieftaincy institution. Now that she's arrogating nakedly, some powers that she doesn't have, power to nominate who becomes the Chief Justice. That's why yesterday I said that she is behaving as if, the position of Chief Justice is analogous, to the position of a chief, and therefore when the position is vacant, then the person to nominate, must initiate a process of selection, leading up to the nomination. But that is not what, we have here. The institution of chieftaincy, is guaranteed under the Constitution, subject to its customary usage, while the judiciary is a creature of law. So the two are not different at all. Therefore, where the president has established a committee to go into allegations contained in petitions submitted, to the president, who has forwarded it to the Council of State, and then in pursuance of that, a committee is established to go into it. The only instance where one can find any fault is where, for instance, the rules of natural justice, were not observed. But here we are. If any Ghanaian can say that, in this Article 146 CJ removal process, the provisions of the Constitution were not observed, then perhaps, that person might not, have been following, what transpired at the Justice Court Committee. So the point is that we must be able to segregate, the jurisdiction of the High Court, which is what is confusing most people. The High Court has jurisdiction, but we must look carefully at the provisions of Article 140. The jurisdiction of the High Court is subject to the Constitution, and in that regard, the High Court, for instance, does not have jurisdiction to entertain, causes or matters affecting or relating to chieftaincy. If you look at Article 140, Clause 3, the High Court doesn't have jurisdiction, in matters pertaining to treason trial. Now the former Chief Justice is likening the whole thing to a commission of inquiry. If you look at the provision establishing, that's Article 281, establishing a commission of inquiry, the procedure is patently different from the Article 146 Clause 6 procedure. The two are not the same. So the analogy being drawn here is inappropriate, and therefore, in the interest of justice, and in accordance, with the time-honored principle that litigation must come to an end. If the matter is a beating Ambil, it means that it has come to an end, and that is why my submission has always been that the office of CJ is not one's personal property, and therefore it is not something that was purposely created for former Chief Justice.
Okay, let me do this. The reason why, well, I may disagree with you that that's the end of it, is because in this new process she's filing, there are two emerging issues that we haven't paid attention to. Her conditions of service, or maybe her severance package, if we should call it as such. And now she's also raising concerns about halting the new either vetting or confirmation process for the new Chief Justice. Are these two aspects grounded in law for you?
On what basis? On what basis? I mean, you see, that's why I'm likening it, to, the institution of chieftaincy. If you were dealing with a chieftaincy matter, I can understand sentiment. We are not dealing with an institution of chieftaincy. We are dealing, with the removal of a Chief Justice pursuant to Article 146, Clause 6. And in Article 146, Clause 6, the person with the most say is the President. And it is the President, the President, the President, the President. There's no reference to the High Court. There's no reference to the rules of law committee as you have, with regard to the commissions of inquiry that she abetted her mind to yesterday, because there, the procedure and governance, is totally different.
So she's lost all her benefits. Is that what you're saying? She's lost all the benefits?
Pardon?
She's lost all her benefits?
That's another matter.
But she's raising that. She's raising that. Yeah.
It is not all embracing. So let us try, very hard to differentiate between her removal, as CJ and the Justice of the High or the Supreme Court, vis-a-vis, her retiring benefits. The two are not the same.
Okay, but do you feel that she deserves that? Do you believe that she deserves that? Because she stated that in some of the claims.
Yes. But as far as I'm concerned, and personally, I think that it is too harsh, to deprive her, of a retiring hour. But the Constitution does not make retiring benefits, as of right. It is subject to the Constitution, and therefore anything that is, subject to the Constitution, must come within the parameters of the Constitution. The President has acted in accordance with the Constitution. Does he have the power to remove with consequential orders? Yes, the President has. And if the President has exercised that power, together, with a consequential, order of denial of retiring benefits, we should be able, to look at it dispassionately to see if what the President did, has the support of the Constitution or is devoid of legality. If it is not devoid of legality, then the fact that she's being denied the retiring benefits is neither here nor there. Therefore, as far as the denial of retiring benefits is concerned, the proper approach is to draw upon one's humility and let common sense speak. It is not a confrontational matter between a former Chief Justice removed by the President, a former Chief Justice denied retiring benefits pursuant to provisions of the Constitution. If the President has the power to remove with attendant consequences, and he does that, it cannot be questioned. If the President doesn't have the power, then it can be questioned. Okay,
Council, I'll come back to you shortly because there's the aspect of the injunction and possibly what Parliament should be doing from next week, because I'm sure that the memo would go to Parliament. The vetting for Justice Bafo-Boni would have to be set in motion. We'll see what this legal process will mean for, the ensuing matters. Lawyer Abraham Amaliba is also on Zoom. I'll come to you shortly. But let me come to Akko in studio because this is not new to you. And you recall at the tail end of President Akufo-Addo's tenure, a petition was sent by lawyer Kukwasari. Yeah, I recall. And the president says, well, all of these claims you are raising has no basis. There's another one now that has gone through, and unfortunately, the former Chief Justice ought to go. She says it's unreasonable looking at, the processes.
Yeah, thank you very much. Good morning to your listeners. The first and foremost point that we have to make is that the exercise being done or conducted by the former Chief Justice Torkonoo, is not a personal matter. It's a matter that concerns the rule of law. It's a matter that concerns our Constitution, the application, interpretation, and enforcement of it. It's a matter that concerns human rights, the basic natural justice rights that a person has to be accorded. I know my learned senior is likening, her exercise to that of a chieftaincy, but that is completely, with all respect, wrong. She has not mentioned anywhere that this is a chieftaincy matter. The Constitution of our country says that if you have been deprived of your rights, if your rights have been curtailed in any way, shape, or form, the appropriate forum is the courts. And that is what the Chief Justice, Torkonoo, has been engaged in. She's been engaged in the courts. When this matter initially arose, she took it to the Supreme Court. She has been fighting in the Supreme Court. To date, none of those matters in the Supreme Court have been determined.
Really?
None. From the very...
What of the processes that
She sought an injunction. The Supreme Court said that we would not grant the injunction, but we'll determine the matter. And then any consequential actions can be taken after that. That hasn't happened. In fact, I know for a fact, and anyone can apply to the Registrar of the Supreme Court to find out, that the Attorney General, who is a defendant in all these Supreme Court matters, hasn't filed a statement of case. They haven't responded. And so it is extremely unfair, extremely unconstitutional, in the manner in which the entire process has been conducted. And if today the Chief Justice is going to the High Court, because now the proceedings are over, she has asked for a copy of the report. And mind you, the Supreme Court has made determinations on this particular matter, i.e., that when the committee process is over, the constitutional injunction of an in-camera proceedings is lifted. What does that mean? It means that every document from the petition, the evidence that is tendered, that was tendered during the process, the reports, every document should be made available.
Do you feel that we've gone past that? Many you say, if you look at the construct of Article 146, everything rises and falls on the president. It's quite a political process rather than law, isn't it?
It is a constitutional process. The president exercises his power subject to the Constitution. That is what Article 58 says. The power that the president is exercising under Article 146 is quasi-judicial, i.e. because he has to make a determination. The second, that's the first one with respect to the prima facie determination. The second aspect is more of an executive function, i.e. the committee makes recommendations and then he has to act on that.
The reason why I'm asking is, for instance, you look at some of the latest claims she's asking for to hold this new process for Justice Bafo-Boni. That's an administrative process, is it? Can the courts really stop that? Because a new appointment has been made by the president.
No. The courts, the Constitution grants you the power, the right to go to court to seek certain orders. One of the orders is a prohibition.
I'm wondering why or how, and I'll give you the.
No, but
I'll give you the opportunity to learn. Just to explain my question, I'm wondering how the Supreme Court will once again enter that whole confrontation with Parliament to tell the Speaker that don't go ahead with your.
She's not in the Supreme. First of all, she's not in the Supreme Court.
Yeah, but whichever court, whichever level.
Yes.
I'm wondering how that's going to happen. That
that's a test
of our land to order the Parliament or the Republic
prohibition not to go.
Yeah,
that's a test of our Constitution.
But is it legally sound?
It is very legally sound. The Constitution says that if your rights have been breached, or if you want to seek a judicial review of a matter that has been taken by administrative body, remember, the Constitution grants you the power to bring decisions taken by administrative bodies that are acting in a quasi-judicial manner to the courts for that to be determined. Now, if the committee has completed its work and the Chief Justice says that this did not stand up to the legal principles, they did not meet the test of stated misbehavior, we need to bring it up for scrutiny. The committee's work needs to be brought up for scrutiny, and that is the only way we can determine whether or not the right thing was done. We cannot sit around the table, in the public domain, have conversations. The president, like everyone else, is subject to the Constitution, and the Constitution grants the citizens the right to go to court, to defend their rights, to defend even the very Constitution itself, to defend the very Constitution itself, the application of it. If there is nothing wrong with what has been done, let the court say so, and then we'll know that this is a judicial precedent. Going forward, this is how we need to treat certain matters.
And that will guide us going forward. I'll come back to you. Lawyer Abraham Amaliba is also joining us via Zoom. And counsel, the question from Eko, really raises eyebrows. The fact that the AG has not responded ever since, that's almost like, I don't know what to call it, disrespect, is it, to the processes going on in court. What do you think? And Lawyer Amaliba, I hope you can hear me. And kindly unmute. Yes, loud and clear, sir. Yes.
Yes. The AG can always go to court and ask for time to file his processes. It's been done. We've seen it several times. If the AG is bogged down with other very important matters, he's not supposed to break a limb and an arm. He can always go to court, ask for leave, and then file the processes.
It's almost as though this government is not taking this matter seriously.
I am saying that once the law allows the AG to appear in court and say, can you give me 3 days, 7 days to file my processes, there's nothing wrong. The AG will do it at the right time. But you see, Torkonoo is becoming a crybaby. A crybaby because at each step in the way, she decides to file processes. Which processes are meant just to stall the legal process that were ongoing. Now the committee has finished its work. This matter, for me, is close. I read part of the release he was seeking. To say that, in your estimation, the matters that led to her removal were not weighty so as to ground stated misbehavior, it's not for her to say. It's not for her. The committee looked at it and saw that this could affect her and said so. Then there was also another one that she said she is of the view that her salary and her remuneration and all those entitlements should be paid. What happened to her has an effect of saying that she never existed as a Chief Justice.
Counsel, so are you saying you will give her benefits? Is that what you're telling us?
Is it me? You are talking like CPC.
But I mean, it's your government. You know the mind of the president by now.
Ask anybody. Such kinds of removal has the effect. And indeed, I was at the Supreme Court at the conference room of the Chief Justice, and I saw all the justices' pictures on the wall, and her picture was missing. That has the effect of what has happened to her. So, litigation must come to an end. And I think that she's better off, taking this in her strides and then forge the way forward with her life.
Don't you think that things would have been much more easier? Don't you think that things would have been much more easier if, for instance, say she's giving all her conditions? That would have ended the matter, isn't it?
That was what this government sought to do when she reached out to the president through, I said this before, and she has never come out to contradict me. And if ever she contradicts me, then I'll now let the facts out. When she approached the president through some two eminent persons for her to retire so that the processes will be truncated, that was the intention of the government, to allow her do that if only she would agree to retire and not go through the process. She reached the president through some two eminent Ghanaians. But now that the whole process has gone to its end and we follow through the process, these processes too have their effects. And if it is not for irrationality, if it's not for breach of natural justice, I don't see how these matters can be overturned by any court or entertained by any court.
So when the approach was made, is it that the president did not listen? The president was not open to, negotiating?
Government was open. Government was amenable. Processes were rolled out only for her. And that was the first time she went to court and subsequently addressed the press. So once she went to court, then the government's hands were tied and that process truncated.
Does this also not suggest that probably all of this that's happening now is premeditated? Is that a fair way to describe it? That, of course, as a government, you knew she was going anyway.
What have I said that suggests that? Just ask a direct question.
Let me give you that. Was this premeditated, Council?
Whether or not it was premeditated, somebody says whether or not it's still the same. So whether it was premeditated or not, it's clear indication that if you didn't do anything wrong, the premeditated mind cannot act on your conduct. So let's focus on what she did. Was it proper for her to flout the rules governing her leave, the misappropriation of funds, because she also presided over such conduct by other public officers? When matters come to court, she presides over those things. If she is now caught in the web, and the bar for her is higher than other public officers, that's what she should know. So no matter how premeditated it was, or no matter how anybody wanted to remove her, if she was clean and conducted herself in a way that wasn't, or that couldn't make it possible for anybody to remove her, nobody could have removed her.
Okay, I'll come back to you. There are some more issues I would want to put across to you, because now the process, I believe, if granted by the courts, will be halted in terms of the new appointment. But Lawyer Ghanamannti is here. Dr. Duchum is also here. Let me get your thoughts on what Ibrahim Amaliba has been saying all this while. He says, first of all, don't think it's premeditated, because the option was given to her, for her to get her benefits and just retire.
Thank you very much. Let me say a very good morning to our citizens watching this morning. You see, a process was kick-started, and we all followed how it went and then how it has ended. This issue of her benefits, which is becoming a second addition, I will look at that later. But if you look at the discussion and the way it's being done, you can see clearly, for my learned friend Ibrahim Amaliba to say that the former Chief Justice of this Republic is behaving like a crying baby, then I can equally also say that the president is behaving like a bully. The Chief Justice is no mean person. She's the third most important person in this country. And from what my senior, the former director of the law school, Mr. Ansasari, said that she's running around. Please, let's begin to stop these things. And kept saying the president, the president, the president. Article 1 of this constitution says that the sovereignty of this nation resides in the people. And government that is formed, whether it's an NDC government, MPP government, will have to exercise government on behalf of the people. Saying the president, as if the president is more important than all of us. It is wrong. Let us start behaving as if the president is important than everybody. It's only in Africa and only in Ghana we seem to make presidents demigods. Presidents are not demigods. They are ordinary citizens like us. In a certain organization called a political party, seek leadership of that party, come for election, and we will vote for them to be leaders. They are no demigods. Look at what has just happened in Madagascar. The people have shown that if you cannot serve the people, we'll put you aside. It happened in Bangladesh. So when he was saying the president has finished and the president has done that, don't try to educate.
Yeah, but there's a constitutional process, isn't it?
And the constitution is clear that the president is not a demigod. Article 69 even says that the president can be removed. So if there's a discourse involving the third most important person, and then the whole argument is skewed towards one person is so superior, it's a demigod, and it's not about President Mahama, it's not about President Akufo-Addo, it's not about Kwame Nkrumah, it's not about Jerry Rawlings, it's not about any of them, it's not a persona. I'm talking about the position that let's begin to move away from this concept that the president is a demigod. When Mr. Ansasari was speaking, he was saying the president has finished, the president has done that. As if when the president says that is all. That is not all. What the woman is doing comes under Order 55 of judicial review. She's seeking to have a review of an administrative decision.
How many times will she do that? Because the writing down the some will say, isn't it?
She has allowed all the process to go on. Right. And now she's seeking to have a review of the process. And it falls within her mandate. Like my learned friend said, under fundamental human rights and freedoms. And it also goes to deepen our democracy and the legal ethos we have. Let's begin to move away from trying to force this narrative of the president, that untouchable. And I'll repeat again, it's not about President Mahama. It's not about President Akufo-Addo. I'm talking about whoever occupies the position, even if it's you, if it's me. You are not a demigod. When a matter comes and we are discussing, let's put everything in its perspective. Let's give the respect to the president. Yeah. And let's give the respect to the Chief Justice. And let's allow, if you look at what the Chief Justice is doing. Right. What are the reasons for her removal?
I was just going to ask you what more it will add or subtract from,
So basically, if we take our time and educate the citizen on what has gone on, you can see that, for me, when I read the processes, I can equally say that we normally say that kangaroo courts are in military regimes and dispensation. This committee, the work it has done, it's a kangaroo committee. Everything it has done is shambolic.
Really?
Yes, because one, the woman is saying that even at the time, you had 3 petitions. You went through only one. 3 petitions on the same fiat. So more or less in court, when they set down issues for trial, 1, 2, 3 issues. 3 issues for trial. A court cannot say, I've determined issue 1 and leave the 2 and come and give judgment. You must determine all the 3 issues. And then let us know the verdict of the 3 issues. The Mahama committee determines only 1, runs with it, and then jettisons the 2. Let's put that one aside. The one is saying that even that particular one, the first one, the Ofori petition, she petitioned for extension of time. Amaliba here saying that Attorney General can go and sleep and then come and always ask for extension of time. If it is true that the woman is saying that even the Ofori petition, upon which has been removed, she filed for, or she requested for extension of time for her lawyers to file things. Did the committee allow her? They didn't allow her. August 20-something, 25th, they adjourned the entire process to September 15th. Only for her to wake up and say that September 1st, they have presented something, they are removing her. You the same inquiry, body of inquiry, the same court. You are a lawyer on the other side, I'm a lawyer on the other side. We appear before a judge. The judge adjourns the case to 15 September. Then I'll be at home, I'll hear that 1st September, the judge is giving the ruling. Is that due process? Is that due process? So from what the woman is saying, if all these things have happened before this committee, and this committee runs, because if the committee adjourned on 25th August 2025 to resume, the next court date, the return date is 15 September. And the same court does not wait. And then 1st September, you run and go and present a result that upon that basis gets. Is that right? Even in the court of law, that will not happen. In court, when a matter finishes, a judge is under obligation to tell the parties that, all right, the matter is finished, evidence has been taken, now my judgment will come. The court will give it. According to the woman, all this were not done. So we shouldn't just be sweeping things under the carpet and come and let it look like
But if
the
you look at
president has finished,
the conditions in,
the president has finished.
yeah, if you look at the conditions in 146, it should be based on a petition. That's what the Constitution says,
Yes.
isn't it? If you have 3 separate petitions, you could rely on one and forget the rest, isn't it?
No.
But it must be within the process.
Yeah.
So let it be known.
Because mind you, well, you know the legal process more than I do. The lawyers did not file jointly, right?
No, it's the same petition on one fiat.
Yeah, no, but that's
So
what I'm saying. So
the president's request for the Poaman committee
Yes.
to look into the matter did not go with separate fiat.
yeah, but I'm also saying
No, please. So I'm giving you the legal
yeah,
implication.
okay, yeah.
If they want the Daniel Fori matter to be looked at,
Yes.
one fiat.
Yeah,
If they want the other one, standing
Shining stars.
but this one, all the 3 of them, so in law, we call them issues for trial. You have
Yes,
set down 3 issues for
yes,
trial.
but what
Hold
I'm
on,
saying,
hold on.
okay,
You are educating the
okay,
public.
yes.
We have set down 3 issues for trial. You finish 1.
Yeah.
Go ahead and finish the other 2. Or even if you are not finished the other 2,
Yes.
say it in open court that, from the view of the committee, within these 2 other issues, they are immaterial. It will not do it. We will only rule on the first one. All these things, according to the woman, did not happen.
Yeah, but what I'm telling you is
Yes.
that these individuals,
If I can support what he's saying,
Yeah.
when the petitions came to President Mahama, and the Chief Justice went ahead and requested for, a copy of it.
yes.
There was a prima facie determination that should have been made, and was indeed made. Now, if you look at the prima facie determination, or what they say was a prima facie determination, it was just a letter. We never got any reasons, and consistently, one of the reasons why she was in the Supreme Court was that let me know the charges against me, so that I can adequately prepare and respond to it. They didn't. And then they made a prima facie determination and a suspension.
Yes.
Now, if you read the warrant that was signed by President Mahama, suspending her, and the referral to the committee,
Yes.
it made it clear that he was referring 3 petitions
To the committee.
to the committee.
But
So
the
you
president
cannot come back and give an answer on only one petition, especially when the prima facie determination did not separate the petitions with respect to.
That's why I'm asking the question. That's why I'm asking the question. That's why I'm asking the question about the filing. They filed in separately. I mean.
Yes, they came in separately.
Yes,
but they were consolidated.
Consolidated,
It's not,
exactly.
it's not about how they came.
the president cannot consolidate for the
Yes.
committee. Is
No, it was not.
But he did. So
It was
that,
not.
so that actually raises another constitutional issue.
You understand?
Can he
The
consolidate for a committee?
And counsel, like you rightly said, if you have 3 issues set down for trial, you have 3 petitions you are dealing with. You don't deal with them in piecemeal. You don't finish the Daniel Fori one, bring it, Mr. President, we have finished this one, deal with it. Then you go and work on the other one, 2 months time, bring it. It doesn't work that way. These are the things the woman is complaining against. And if she's complaining against these procedural errors, she's simply trying to say that in sum, whatever happened at this committee cannot stand the test of time because it doesn't give the proper legal disposition. And me as a lawyer, what I'm trying to say is that let's look at those things. If these are the things she's raising, then to deepen our legal jurisprudence, we must look at these things. But we cannot come to the citizens and tell them that all these things. Mr. Ansari was a former director of the law school. So he should educate the people strictly when it comes to the legal dispensation.
Okay, this is what I'll do.
Sweep the things under the carpet and try to say that, and the executive alone doesn't make the country.
Okay, this is what I want to do. Because lawyer Ansari is still with us, probably I'll go to him on Zoom shortly. But let me just come into the audience. Probably, Kamal, you have a point to make briefly about this.
Listening to the legal practitioners, one thing is clear. I've said it that the Chief Justice was already targeted even in opposition before the government assumed power. So all these things the government is doing is just to frustrate her more and let her give up. I will say that at a point, much as I share in her pain,
you feel she should give up?
I feel like she should just accept fate and move on because I don't see her getting justice under this government when they've already made a fait accompli case on her. So I'll just encourage her to just move on and look at other endeavors and let it be because she will never get the judgment. People who accuse our judges to be running a unanimous FC are in power and basically the same thing is happening. So where lies the tag you gave it? But President Mahama by now should have even be worried because just as they said, no, how when I heard about the case, the final determination, and I asked, what of the two? And then they said, that one, you don't even know whether they will revisit it, whether it's gone for good. You don't deal with the top third most person in the way they treated her. That I think is very, very unfair. If she's the Chief Justice and she's treated this way, a commoner like me, what then happens to me?
Great question there. Yes, go ahead.
Yeah, I respectfully object to what he just submitted. Let me quickly go through this. I think we should begin to look at the constitutionality of the whole process since, its inception. Let's not forget that the first petition was filed under the Akufo-Addo regime. And if he says, he's making the whole thing look as though...
he's talking about the earlier one. But that was by a different individual.
A different person.
Yes,
but
yes.
His submission more or less paints the image that it's a personal vendetta against the Chief Justice from the office of John Mahama.
Yes.
But let's look at the whole legality and constitutionality of the whole process. Right from the inception, has the process that needs to be executed be followed diligently? The issue was laid before a standing committee. Was the appropriate measures that were supposed to be taken met? What suggestions were given? Now, these committee, if there's any loophole or there's any discrepancy in what they suggested, that should be looked. We shouldn't make the battle a battle between the two organs of government. It's not painting a direct image. Then again, we should be very careful in the way we are treating the office of the judiciary. This is a very pivotal and cardinal office in our democracy. And so I respectfully object to what he said. He said that it's more or less the president is carrying out a vendetta against the Chief Justice.
I get your point. In fact,
it's not in reality, as I said now. It's not in reality. And quickly, I would like us to tackle everything, reasonably what she's demanding. If it's a retiring benefit or
then we give that to her.
Yes, let's just give that to her. But
okay.
I just don't want to.
You don't want us to paint that picture. In fact, that's why. But that's why I was asking Lawyer Abraham Maliba earlier. I'll come to you, Dr. Duchum. Let me, because Lawyer Ansari's name has been mentioned. Counsel, let me find out from you what you think about what Tekor and Lawyer Wayoe are raising about, the process, how the committee even arrived at the conclusion. You have 3 petitions before you. You deal with just one, and you leave the others. Is that not selectivity then?
No, not at all. You see, it's a matter of procedure. In civil procedure, we have a process called consolidation. So you may file 100 suits, and if they contain or relate to coterminous interests, you can apply to have one and the 99 others consolidated, so that the 99 others will abide by the decision, in the May one that will go to trial. So in this vein, 1 out of 3 petitions, was considered. The inference, therefore, which is a reasonable one, is that the 2 other petitions will abide, by the determination or the petition that was, considered. Now, the moment that process, is resorted to, it means that the 2 other petitions will become moot. And in law, when they become moot, they are not looked at again because, the 2 petitions were considered, and the primacy of those petitions merged, into the one, that the Scott Wama committee, determined. And
because the committee,
all 3 petitions had been considered. That is, the procedure that was, followed. Now, the question is, was it backed by law? Yes, it was backed by law. It is, a process known to our jurisprudence, and no one can fault it. Now, as to
Counsel, I was just going to ask, based on that point you're raising, because the process is shrouded in secrecy, or it's an in-camera hearing, what then would determine the priority for this committee? How do we know, of course, what influenced the decision to rely on one and to leave the others? Would that not raise a transparency issue?
Well, because the former Chief Justice did participate in the process, one can assume that she consented. And if, the one that was chosen, was chosen by consent of the parties and their council, it is too late to question, that process. In any case, the committee, could itself, have selected, one of three or decided to deal with all, three en bloc. That is, it was up to the committee. Now, I see what is going on, the latest actions of the former Lady Chief Justice, as seeking a review, of what has happened. That cannot be done. It has no support in the law. She was heard, she presented a case, she was given the opportunity to ask questions, she was cross-examined and all that. So the rigmarole, or the judicial, process, came, into sharp focus, during the determination, of the petition. And the other thing that, the High Court, can entertain applications is misconceived. You see, the expression supervisory jurisdiction within the intendment of Article 140 of the 1992 Constitution, it has been explained in Article 281, Clause 3, what supervisory jurisdiction means. Now, if you look at Article 281, Clause 3, it is quite clear that it does not extend to or straddle into matters, determined by a committee set up under Article 146, Clause 6. So let us not confuse the two. The High Court has jurisdiction, but Article 140 makes it quite clear that the jurisdiction of the High Court is subject to the provisions of the Constitution, and therefore, by parity of reasoning, it is subject to Article 146, Clause 6. And if it is subject to, it means that the High Court cannot, straddle itself into areas the Constitution has not given it authority. The High Court is a creature of statute. The Constitution has spelled out what the High Court can do, the areas it can, its sphere of operation. If what the applicant is seeking is not contained in the Constitution, the High Court cannot do anything about it. It means that as far as this is concerned, there's an ouster clause. Article 281, Clause 3 is, operating as an ouster, clause.
Councillor, did you say 281? Did you say Article 281? Is that what you're referring to?
Yeah, 281.
Because some colleagues here are raising concerns.
Supervisory jurisdiction.
Some colleagues here are raising concerns about the provision. That's why I'm asking you. 281(3).
1 and 2.
Clause 3.
There's no Clause 3. 281.
Or are you referring to 282 then?
281 has Clause 1.
28. I'm sorry. I think it's 278.
Yes.
Oh, okay. You're referring to 278 C.
Let me. 28.
Because 278.
So 278
C.
is on appointment of commissions of inquiry.
Yes. It says that.
And 281 inquiry procedure. Yes, the inquiry procedure.
Okay, so it doesn't have Clause 3, but it has Clause 1 and 2.
It has only 1 and 2. That's why
There's a clause dealing with.
Okay, I'll just give you the time briefly to look for that. So whilst I bring in lawyer Abraham Amaliba and counsel. Okay. Let me hear from Doc first, and then while you look for that. Yeah, sorry about that. So,
no problem. First of all, thank you very much for this opportunity, and let me send my regards to our viewers. I would like to separate the issues. I think the first thing we should be concerned about as ordinary citizens is the constitutional provision that empowers the president to go through this process. And that one, I think, listening to both sides, you cannot, I haven't heard from the Chief Justice. She is making claims of the way the process have gone. But I think that if you follow it, objectively, you see that the president, it's difficult to fault the president for abusing the process. But what I hear from my colleague from the CPP is quite unfortunate. And it's unfortunate because I'm wondering how, whether it is strategic or is inures to the benefit of our lawyers to always try to abuse the process. Because from what he's saying, my understanding is that there were 3 petitions, right? And the president submitted the 3 petitions to the commission that he has established. And the commission made a determination from 1 petition. I think that is a case that can be fought on, whether the recommendation from the Puaman Committee was indeed can establish a prima facie case for the removal of the Chief Justice.
Lawyer Ansari says consolidation was done.
Exactly. That's what
that's what I have said. So why are you disappointed?
I see.
That is the question to be answered. And that is the reason why we have so many cases pending in our court. Because our lawyers will try to use technicalities to raise issues. Because I'm looking at the effect. So what is the effect? If the 3 petitions have gone through the process, what will be the effect? So I think the key question to be answered is not to go through the process and spend over a year to establish whether there was a case or no case. Then the second issue that I think that it will be very important for us, objective minds, to look at is her entitlement. And I think that we need to
Do you feel that we should be more focused on that or on the court process? Because she seems very interested in the court process. I don't think she's...
Because that is the system. A country must build system. It's not about... If you move to entitlement, we are talking about money, material stuff. No, hold on. You have time. If the country does not move to establish systems and you chase materialism, you lose it. The Chief Justice is more concerned about what is happening to me today, what I'm going through today. His lordship, Bafoboni, if he becomes Chief Justice, and if he doesn't go early based on retirement, and another government comes and goes through the same process, it will be unfair.
I'm not advocating for that.
She's looking at the system.
I'm not advocating.
And that is where as lawyers
benefits in relation to the
benefit.
process.
What is benefit?
I'm saying that constitutionally, I'm not a lawyer. Constitutionally, it's very difficult to fault the president for not following the process. If you follow step by step,
she's not faulting the president. She's faulting the committee, not the president.
No, I'm saying that the president went through a process. All the players in this case are working under the initiative taken by the president. If the president had not taken the decision, because in President Kufuor's time, and I asked my friend that there was a petition by Professor Asari. It was basically dismissed. And what questions did we raise? The president had that mandate and the right to dismiss that petition. Of course, respecting the position of the Council of State. In this case, it's the same. The Council of State was consulted, and the Council of State advised that, yes, there is an establishment of prima facie, so you can proceed to the next step. The president did that. And I'm not, well, don't get me wrong, I'm not taking the right of the Chief Justice to seek judicial process and establish that her reputation is intact, because it enriches our...
It's not about her reputation. No. It's about strengthening the system.
I'm saying that.
She's not doing this for her reputation. She's doing this to strengthen the system for posterity.
It will help us to consolidate our democracy.
Exactly.
That is not in doubt. But I would like to conclude that, we have to be critical and very objective. For me, I think the way we have politicized the whole process, and especially, you see, you cannot fault only the NDC or the President Mahama. The MPP. Why is it that the Chief Justice... You feel
they created the problem?
I'm saying that the Chief Justice, the former Chief Justice, in my view, actually misjudged by allowing the MPP lawyers to take over her case. Yes, her first lawyer was the former Attorney General.
That's a controversial one you're raising.
He's a UP man. The Chief Justice, the former Chief Justice, has every right
I'll go to Amaliba and come to
select every lawyer she wishes. Absolutely. That is only, but is here called. There is something called good judgment. And we are faulting the president for not exercising good judgment.
You feel that she shouldn't have gone with...
As an objective, you see, ordinary Ghana will sit down and see, you are appointed by a certain regime.
Okay.
A certain regime appointed Godfrey Dame. Godfrey Dame is my friend. But I think if I was Godfrey Dame and I was approached by the Chief Justice, I would turn it down. I would turn it down because we are in a political ecosystem. We shouldn't think as if that when you are speaking, you should speak and people should listen to you. Is it fair? I'm asking anybody, the four of us and those outside. is it proper? What will an ordinary person see? Or what will be the perspective of an ordinary person? That the lawyer for the Chief Justice is the immediate past Attorney General.
Even better,
all people support it, including ECHO, was the counsel to the president. Do you know? Because we believe in the institution. But I'm saying that the representation itself is symbolism of the way we've politicized it.
You are rather contradicting what you're saying. You are rather contradicting what you're saying. That, you know, the matter has been politicized. And you are saying that she cannot choose lawyers of her choice.
I'm not saying that. I'm saying that in my view,
let me do
it
this.
reinforced the position that MPP is streaming behind.
Right. Lawyer Abraham Maliba, let me hear from you. I'll come back to you. Two questions facing you. He's raised. I mean, how the Council of State and what sort of legal advice you gave to President Akufo-Addo on the initial petition, and also the decision to represent her. We'll come to you. Lawyer Abraham Maliba, let me hear you.
Well, I want to put on record that the committee did not only review the petition sent to them by the businessman, which eventually removed the Chief Justice. I'm aware that the petition that was forwarded to them by the police officer, ASP, I think so, was actually looked into. And, you know, his case was that he was locked up by the Chief Justice. He couldn't find his records of proceedings. And the committee came to the conclusion that was not enough to, as it were, remove the Chief Justice. So I want to put on record that that petition too was looked at. It's not only the other one. But in any case,
you this morning, Council, the question to you this morning is how did you get to know of all of these? That's what your colleagues are asking you this morning. I mean,
he's speaking on authority.
The claim is that you're speaking on authority.
About events that are supposed to be in camera.
Because something that is in camera. A senior member of the NDC.
And the whole country is listening.
Even those negotiations that went on in the background.
I get that. Let's allow him to answer.
It was supposed to be in camera. It was supposed to be in camera.
Let's allow him to answer.
And now an NDC officer says he is aware.
Council.
I mean, so was that in camera, or it was in the house or in the rooms of some group of citizens?
Okay, he was an ex-official member of the
Let's allow him to answer. Council, over to you.
So, if you are asking me these questions, how did I know? Then stop asking me questions that are premeditated questions that are not in the minds of people. You are barred from asking me questions related to premeditated minds. If I can't reveal this, how can I then reveal premeditated minds? So I'm saying that that did happen, and the committee dismissed the police officer's case. But in any case, if the petitions are supposed to remove the Chief Justice, they are not supposed to pamper the Chief Justice. They are supposed to remove the Chief Justice. And after reviewing one, it was sufficient or adequate to remove her. Well, why are you bothered about the other one? Will the other ones bring her back? Will the other ones bring her back? So, and my senior Ansar will tell you, it is not just about lining up witnesses who come and repeat the same thing in court. If your witnesses, no matter how many they are, it cannot enhance your case if those witnesses are just coming to repeat the same thing like what the first witness came to say. So you are better off having just one witness who can make your case and the judge will rule in your favor. So in this case, let's even assume that there was no consolidation. There was one petition, which petition succeeded in removing the Chief Justice. What are you going to repeat the others for? So that to undo the first one. So I want to think that we can put a human face to her predicament now. And that human face has to do with her remuneration, her entitlements, and all those things. Because I'm sure then the day that the letter went, I'm sure they would have truncated her salary immediately. That can be problematic. Yes, she may not have her name again as a Chief Justice, but in person, she was once our Chief Justice. You don't want to see our Chief Justice, in a condition that is unacceptable. So we can make a case to put a human face, because this is the first time that this has happened. And so there are no rules to govern these matters. It is now that I'm hearing Parliament wants to make rules to determine these matters. So let's argue for her on the basis that she should be given her entitlement. That's, I will argue alongside.
All right.
But to try to fault anything, I can't see it.
All right. Lawyer Ansari, are you still there with us? Have you found the article you're referring to?
Yes, it's Article 1613.
Okay, 1613 now. Okay, yeah, I think the lawyers will look at that.
Thank you very much.
Oh, okay.
I apologize.
Yeah, I get that. Let me just give a quick one to Echo, because the question on what informed President Akufo-Addo's decision in the lead up to the 2024 elections, of course, there was a petition by lawyer Kwaku Asare, not the one on Zoom, but the one in the US. You turned that down, Echo. I'm speaking extensively by the president gave his reasoning, said the Council of State doesn't see any reason on that. Yet another Council of State is now recommending that, of course, there's enough evidence.
First of all, once that matter had been determined, it was wrong for the committee or President Mahama to make a determination that there was prima facie case. Professor Azar had every right to challenge the determination made by Akufo-Addo. In fact, the law gives him 6 months to challenge that determination. He didn't do that. In law, there's something called res judicata. That is, if a matter has been determined on its merits, you cannot bring it back. You cannot relitigate the matter. When President Akufo-Addo received the petition from Professor Azar, it was after the election. It was during the Christmas period.
Yeah.
The Constitution required that he consults with the Council of State. In fact, that requirement was incorporated into the Constitution by virtue of the case E.J. Chum, an Attorney General, which said that if you read Article 146, there isn't any provision that allows for a prima facie determination, unlike for justice of the superior courts. So it said that in that case, the president should make a prima facie determination. That determination is the decision of the president, not the Council of State. He consults the Council of State. And the consultation of the Council of State is not binding on the president. It's merely advisory.
Did you see his post on Facebook? He criticized, the legal team of the president, Kwaku Azar, after the decision was taken.
He's entitled to it. And I can tell you, because now the proceedings are completed, the constitutional injunction is lifted. The Council of State came back to the president. First, they held meetings with the president on this matter. And they advised the president. And then they wrote an opinion, a very strong, legally worded opinion on the matters that Kwaku Azar had written in his.
Was it not the case that President Akufo-Addo, and by extension you, the lawyers working with him at the time, were simply defending the Chief Justice?
No, we had no business with the petition when we were consulting. And the law requires that the Council of State consults a reputable lawyer. And in this case, they did. They consulted a reputable lawyer. But mind you, there were also reputable lawyers on the Council of State. There was a former Chief Justice on the Council of State. It is for no reason that the provisions of the Constitution require that when you are constituting a Council of State, you put a former Chief Justice on there. Now, the former Chief Justice, who is on this current Council of State, has spoken bitterly about this matter, that it didn't follow any due process, that it breached the rules of natural justice. I mean, because the decision was President Mahama's decision, he could have called her and ask this matter that has come before me, what are your thoughts? Because you are a former Chief Justice.
What do you say to the fact that, to the concern that Dr. Educhum raised, that you were the ones who made this case worse? Because as people who were politically exposed, you shouldn't have gone into the defense of Gertrude Torkonoo.
I totally disagree with him. We are lawyers first. And as lawyers, when we see something that is not right, we need to speak up.
Yeah, but all the lawyers we've seen so far, connected to the NPP, does that not raise questions?
But then you should look at the stature of those lawyers, the work that those lawyers have done. In other jurisdictions, for instance, these are lawyers who do maybe Supreme Court or appellate, court litigation. And the experience those lawyers have.
Are you saying that outside the...
Oh, hold on.
No, outside the NPP, there are no experienced lawyers who are sympathetic with the Chief Justice.
No, it's her right.
So she's only seeing all of you. There are more senior lawyers.
Well,
you agree.
The lawyer that has filed the matter...
Yeah, with all respect to those who are defending her, but I'm just saying,
she has a huge legal team.
Yeah.
It's unfair for you to say that...
No, with respect. That's why I said with respect to those defending her.
Yes.
I'm just saying that...
She has a huge legal team.
Those lawyers, don't they have seniors? They have seniors, obviously, who may not necessarily be politically exposed.
Would you say Edukusi is a...
No, I'm not saying so. I'm just saying, that's what I'm saying with respect to the individuals.
Bonzi Simpson would you say he's MPP?
I'm just saying.
Professor Bonzi Simpson. No, these are lawyers that are interested in building the institutions of our country. Because what the Chief Justice is doing, and we should commend her.
Okay.
We should commend her because what she's doing, let me land. What she's doing is to embolden our judges to be able to defend the citizens.
All right. I'm told that we need to take a break now. When we get back, I'll give you the take, and also Dr. Educhum is here, and probably we'll close the chapter and look at United Party. Please stay with us here on Prime Insight. We'll be right back. And yes, you're welcome back to Prime Insight. How about taking some of your messages coming through? Thanks for sending them. This one says... this one is from Teacher Constituency in Wemwase. I think that's the name of the place. It says, JDM's NDC government is a recipe for disaster. They are running Ghana's future down. Ghanaians will reject them in 2028. It's time for a new direction, he says. The NDC actually lack transparency, and their transparency or public trust has eroded, he says. Kweku Boateng on excess, Justice Torkonoo should just go home. We're very busy doing institutional reset. Long live John Mahama. So, depending on where you belong, of course, you'd have your political say on the removal of the Chief Justice. Let me come into the audience and then get the concluding remarks of my panelists on this Chief Justice issue. Yes.
Okay.
And kindly introduce yourself so that those watching can also get to know.
Okay, please.
Yeah.
Emmanuel Edu. So, I had the former Ghana School of Law
Director,
professor, as I said, it's not mandatory for the Attorney General to respond to the suit. And we are talking about the Chief Justice, the highest of our judiciary. And for him to say it's not mandatory.
I think it was lawyer Amaliba, rather. Yes, who was saying that.
For him to say it's not mandatory or whenever he feels to respond.
Yeah, you don't feel this right?
Yeah, I think we are not taking this matter serious enough. Yeah. They've already premeditated something that we will do what we want to do, and no matter what everybody said, this is what we
all right. Okay. Probably okay. The young lady also wants to say a few words. Yeah. Let's hear it.
Okay, so I just want to say that we should pay more attention to the system, not really about her benefits. Yeah. Because whatever is going to happen in this system is going to serve as a precedent in the future.
The others, yeah.
So you should pay more attention to. And then I also have a question. So should the Constitution, that particular article that enables the president to form a committee should it be amended? Do you think there should be any changes attached to that?
I think that's a crucial question you are asking, and perhaps maybe I'll put that to Lawyer Ansari and the others. Okay, Kamal, you want to come through?
I think I would like to highlight or magnify what Lawyer Amaliba said.
Okay.
He became very evasive Because something.
You think so?
Yeah, very. When counsel asked him that question, because something that was supposed to be in camera, you are on a national television saying that this. You have on record.
He's a senior lawyer in the FEC.
Regardless of his position, the issue should be in camera, which he wasn't a party to be part of that committee. So the fact that he's even said this has exposed all that transpired. So we want Ghanaians to know that the fact that lawyer Maliba said it emphatically that the issues were looked at, meaning he was privy to whatever was transpiring in camera.
The Chief Justice, the embattled Chief Justice, or the former Chief Justice herself, and some of her assigns are also out with portions of issues that transpired during the process. You didn't fault them for that as
I've not heard them. What I heard this morning was what lawyer Amaliba said, and that is what I'm speaking to.
You want to base it on what you've heard? Okay, yes.
Just like some quick clarification on some very
points that were raised,
statements the lawyer churned out. And he said he labeled the committee as a kangaroo committee, and so to speak, labeled the president to bully the Chief Justice. Now, can we not just agree that the process right from the word go has been constitutional?
You feel the president, once the president has checked the boxes, that's the end of it for you?
I think the whole thing ultimately relies on the committee. I stand to be corrected, but it relies on the committee. And so whatever provision the committee comes out with, I've been following, keenly, and just to say that I don't see a point where the committee's actions could be...
Do you honestly think that the president was helpless in this case, that he couldn't have done anything? I mean, honestly speaking.
No, I don't think the president was helpless.
Yeah, so that's why many are saying,
he could have intervened. Everything was in pursuant to Article 146. I believe so. And so to label the president to bully, the Chief Justice,
you disagree?
I disagree respectfully.
Okay, your colleague there also wants to chip in something. Yeah, briefly. Yeah.
I heard lawyers saying that the case was adjourned on 25th August, and then they were supposed to resume on 15th September. But then they gave the letter.
The decision before the 15th.
Yeah. Is it right to do that, or is it that they had something against it?
Yeah, great question there, and that's why you're raising some questions.
Exactly, blessed. You see, to take it from my youth over there, I'm saying that if people who are in favor of the position come out and say the Chief Justice is a crybaby, somebody also says she's running amok. And I'm saying that, then I'm also positioned to say that then the president is bullying. So don't misquote me. I'm simply saying that don't let us see the president to be all too powerful than the Chief Justice of the Republic. Yes, the president was voted for, but the Constitution, our laws, place them in that order. A Chief Justice of a Republic is of no mean status.
But if you look at the spirit of 146, and I keep saying that, don't you feel that it's more, it rises and falls on the president? Whatever the president decides to do, that would be the end of it.
No, because at the end of the day, what happens under 146
because if you
can
look
be tested.
I'll give you the opportunity, but even look at the provision for suspension, for instance. Once you determine on the face value of it, you could go ahead as head of state to say, okay, well, go be at home for some time.
Listen, that's the miseducation that we are giving to our citizenry.
But that's what the law says.
146 must not be seen standing alone. Let's come to chapter 5. From Article 12 to 33 on fundamental human rights is superior. Anything you do under 146, if you breaches something under chapter 5 on fundamental human rights,
because it's entrenched, you mean?
You understand? So when people are trying to let it look like 146 is sacrosanct, you can't touch it. So because it is skewed towards the president having the final decision. If a final decision comes under 146, a president carries it out, and we can see clearly it's a blatant disregard for this citizen's fundamental human rights. We shouldn't do anything. It will go to court, and the court will have the final say.
I see.
So in fact, in anything we do, it is the court of law that have the final say.
Because of time,
and that's why the Chief Justice is no. But I want to, just 1 minute. I want to say that Lawyer Abraham Maliba should not let us sweep issues under the carpet. We cannot begin to have. When President Obama came here, he said strong institutions,
not strong individuals.
If we have such a matter, let's not sweep the processes under the carpet and concentrate on material things that let's look at the benefit.
Because I want us to talk on this UP issue. It's very important to you. Okay, then let me give the concluding remarks to those online, and then we move to the next chapter. I'll do that. Okay, so Lawyer Abraham Maliba, your concluding points on this, and also then I come to Lawyer Kwasari.
I've concluded.
I see. Lawyer Sassari is with us. You want to make any final points on this?
Yes, my final remarks, actually for the president, that I appeal to the president, to deal with this issue of retiring benefits with a human face, to borrow the words of my good friend Amalima. Because at the end of the day, her ladyship, former Chief Justice Torkonoo, remains a Ghanaian citizen. And her plight now has become a matter of national worry and concern. And therefore, Mr. President, being a father of the nation, please, kindly, listen, to what is going on now and handle Torkonoo's retiring benefits with a human face. God will bless you if you do that.
We can say amen to that. And thank you so much, Prof, for spending some time with us this morning. Grateful for your time here on the show. So now let's move into politics. But Koyi, you wanted to add some...
No, I just also wanted to just make concluding remarks so that we can talk about UP.
Yes.
UP
your new baby.
I just wanted to be clear that this matter is not a personal one.
Yeah.
I would entreat citizens to try and read the process that has been filed by the Chief Justice Torkonoo. And you will realize that the matters that she complains of are very serious. They are very fundamental. She complains of the committee itself, the person who chaired the committee having been a judge who had written, rulings or judgments in favor of the petitioner Daniel Ofori. These are serious legal matters that need to be looked at, which is why it's important for the entire process to be brought up and scrutinized and see whether that process fits within our legal framework, fits within our constitution. Yes, there's a constitutional process that requires you've gone through an order procedurally, but the substantive due process, i.e., was the law followed? Or, did it rise up to the standard of stated misbehavior? The matter about the travel policy is completely, if you read the documents, you realize that it's completely misconceived.
All right.
And the last point I'll make is that even the issue of what she's fighting for is even to the benefit of whoever will succeed her.
Right.
Because the issue of transfer being an administrative matter, if you read her action, you realize that it was not, born out of any malice or whatever, And if a matter of just exercising administrative power of transfer can, result in your removal, then maybe the current, acting Chief Justice could also, be put in that position.
Okay.